Good afternoon, everyone, and I'm delighted to welcome Stephen Maijoor to this conference. Stephen's been the chair of ESMA since taking up the office in April 2011, and he was the first chair of the authority and is currently serving his second five-year term. He's responsible for representing the authority as well as chairing ESMA's Board of Supervisors and the Management Board. Previously, he served as the head of the Dutch Financial Markets Regulator, the AFM. Now, ESMA is an independent EU authority that contributes to safeguarding the stability of the European Union's financial system by enhancing the protection of investors and promoting stable and orderly financial markets. Stephen will describe ESMA's 2016 work programme, its priorities and its activities, and how it will undertake those activities in pursuit of its statutory objectives. I think it's fair to say that ESMA's priorities for 2016 signal a shift from rulemaking towards implementation and promotion of the convergence of supervisory practices. I hope that we can cover the key elements of your 2016 work programme in our 30 minutes. And I'll try and find time for questions from the audience. I do believe we have microphones available for that purpose. So, Mr. Maijoor, let me invite you to comment first on your 2016 work programme. And I think you've been particularly busy on MiFID II.
Well, thank you very much, Robert, for that kind introduction, and thank you very much for inviting me to this big ICMA event. It's always very good to be here. And as you rightly say, you gave a very good reflection of the main points of our work program. We have been going through the regulatory reform in the past 5 years. The audience has really seen the impact of that reform. We have had EMIR. We're now in the middle of MiFID. Of course, there will be some other pieces of legislation still coming up, like the benchmark regulation and the securities financings and transactions regulation. But overall, the rule-making phase, we're getting to the end of it. And now we're moving to the implementation. We see a very important role for ESMA to make sure that the implementation is done properly. That also means that we will change the instruments that we use. As you are aware, the regulatory reform is very much driven by technical standards or giving technical advice to the European Commission. Now we're moving to supervisory convergence. It will be about a range of instruments that we have, varying from Q&As to opinions or to guidelines, to make sure that there is consistency in the national implementation. So I think like any regulator that is involved in implementing legislation, the phase after making the rules is important. I think especially for ESMA, the consistency across the 28 member states is very important. On MiFID, I can give a bigger response or a smaller response. I don't know what you're looking for. I think on MiFID, we have delivered all our technical standards, or most of our technical standards, in September 2015. So that was all of the technical standards on the market side. These were about 28. We had hoped that they would be endorsed within the 3 months period by the European Commission. It has taken a bit longer, and we recently received the letters that on 3 technical standards they, in principle, want to endorse them, but with amendments. And so we have reacted to that and resubmitted 2 of the 3, which is one is on both market transparency, and the other one is on position limits. But let me stop here.
Well, yes, I think what we can appreciate is the IT challenge that you face at ESMA, building the systems that can cope with all the transaction and reference data that you're going to be required to provide the market. Because you could talk about hundreds of different trading venues and maybe millions of different financial instruments. And I think last year at this conference, you mentioned that I think it was 16 EU member states had decided to give ESMA the responsibility for collecting their data, and that data then going on the ESMA website. I mean, is Are there other countries that have joined? Am I right about the 16 that have decided to give you that task? And just being a little bit heretical, if I may, is there a chance that 16 may grow to 28 to all the member states? And would that be a scenario that
yes,
you give any credence?
We are now at 30, and that might surprise you in terms of a number, but the reason is that also around the table of ESMA are the EA states. So there's also Norway, Liechtenstein and Iceland around the table, and some of them have also agreed to participate. So that is the reason that we're now at 30, not in the total of 31 or 32. And as you rightly said, when we were there last year, the data obligations under MiFID are quite extensive, and this goes back to the fact that we have a responsibility for stability. We don't have a long tradition as securities regulators to collect data on securities markets. We don't have the same tradition as our banking regulators and insurance regulators. And so if you go back to many pieces of legislation that were issued in securities markets in the past years, there's clearly many more data obligations varying from data on derivatives, data on leverage of asset managers. And in the case of MiFID, there's data, there's so-called reference data, which is the needed for the identification of the individual financial instruments, and there's also transaction data. For a big part of the MiFID data collection obligations, as you rightly say, there's been the will by a very sizable number of competent authorities, and I just said we're now around 30, to delegate that up to ESMA. That was a difficult process to get there, because that assumed what will delegation mean and what will be the cost. So it was kind of trying to find an equilibrium. And when we talked the last time, last year, the equilibrium was at 16, but then a few other authorities reconsidered their calculations and thought it's much better if we participate. I think the very good news, therefore, it will be still a massive operation in terms of IT. I think the good news is that this will result in much more consistency in terms of the data collection, although in some cases what has been delegated by all of the 30 that I just mentioned is the publication of the reference data by ESMA and do the reference calculations. Some of them will still collect the information themselves, but I think we have made a big step forward here in trying to get to more consistency. Maybe because this all also relates to the technical standard on the transparency obligations and which financial instruments we consider to be liquid. That was one of the 3 technical standards where the Commission said that that they wanted to change it with an amendment. The main concern, and as you're aware, this technical standard is about how do we first define which bond is liquid, and once it is then liquid, there's going to be transparency, both pre- and post-trade transparency obligations. The Commission is concerned about the current liquidity situation in bond markets and said we should do that with a phase-in over 4 years, going to the more restrictive definition of liquidity. We in principle support going to this phase-in, considering the concerns about liquidity, and you want to be sure that if this starts to be implemented, that it doesn't negatively affect the liquidity in bond markets. However, what we propose is that the phase-in is already included in the technical standard, so that market participants are aware of the trajectory of the plan, that there is more legal certainty, and also I think instead of the alternative model which was suggested by the Commission, is to do it through every time a change in the regulatory technical standard. So I thought it would be good to add that point, because I think it's also relevant for your audience.
Oh, no, I think you'll find this audience has been very impressed with the way you've addressed that particular challenge. And I think I saw some estimates that maybe only 5% of the market may, ab initio, from the start, be brought within the scope of the pre- and post-trade transparency.
Yes, so the original technical standard that we submitted in September last year, in our view, was already a careful standard, because as you precisely say, we had such a calibration of the number of trades per day, the amount of trading and the number of trading days per year, because it was not only the number of trades per day that determines whether a financial instrument is liquid, but also these two other criteria. On that basis, we already thought and I think we had a careful calibration. Even that careful calibration led to a result that 5% of the European bond market would be subject to these transparency obligations. Still, we support this phase-in, but the 5% will then be met after a 4-year period. So the good news is, I think, that the Commission accepts the end goal and what is there in the technical standards. They want to get there in a more phased-in approach, which we support. But as said, I think the phase-in should already be there in the technical standards, so there's clarity for all market participants what the plan is and what the trajectory is towards the definition of liquidity.
Well, thank you for that. And perhaps I could just move subtly to a topic that phrase you've already mentioned, Mr. Maijoor, which is supervisory convergence. And I know you care a great deal about creating a level playing field within our capital market and preventing regulatory arbitrage or a race to the bottom. I think that was a phrase you've used in one of your speeches. So if you could just comment for us on how you see your supervisory convergence work program specifically and the implications of that for our industry.
Well, as I said, the supervisory convergence is now, of course, direct supervision of trade repositories and credit rating agencies will continue to be important. Our risk analysis will continue to be important, but I think where there will be the biggest shift will be from the single rulebook area to supervisory convergence. In the single rulebook area, we will still revise technical standards if we see that they can be adjusted and can be improved. But in the supervisory convergence area, what that is indeed about helping with the implementation of the new legislation. For those of the audience that have been involved in previous pieces of legislation we have been involved in as ESMA, for example, the first phase we really help with Q&As to give clarifications to the level 1 and the level 2. And so I can also encourage ICMA members to submit their questions on the implementation of MiFID, or where there's clarity would be helpful, and that we can consider that for a Q&A. We, in the past, to decide on whether we would do a Q&A on a certain topic, it also depends on how many questions we get on that issue from market participants. I understand that the systemic internalizer regime is an issue where there is unclarity, or where there would be a value in giving more clarity with Q&As. There might be other issues where there's the demand for more clarity. It would be important to get that feedback and then subsequently do that with the Q&As and give that clarity. So clearly MiFID and the MiFID implementation is one of the top 3 priorities in our supervisory convergence program for this year, including the IT issues that I just mentioned. Other areas, maybe a bit further removed from this audience, is everything that relates to CCPs and derivatives, partly because, although that is already, EMIR is already on track for a longer time, derivatives is an area where it's extremely important to be consistent across the member states, because it's so susceptible to regulatory competition and slight differences in the practices and supervisory practices across the member states. So MiFID will be important, including the IT systems. EMIR will be important, and consistent supervision of CCPs. And finally, areas that are important for us in terms of supervisory convergence relating to the Capital Markets Union. Some of that is in the area of asset management and related to the passporting regime. And also some of that, which might be relevant for your audience, is the issues relating to prospectuses. We are just in the final stages of concluding a peer review on national supervisory practices regarding the vetting of prospectuses. I think that is also very important to try to get to be consistent in that area.
Well, you've given me the chance to move on to the next topic, which is Capital Markets Union. And it's a topic you spoke about at our conference last year. And I would like, if you would, just to update us on how you see that subject developing, particularly in the area of SME finance and securitization. And I can't resist referring to the fact that publicly earlier this week you did comment on the adverse implications of capital markets union should there be a Brexit. That's perhaps an ancillary question, but if you could give us your thoughts about how you see the development of the CMU and perhaps in that regard the implications of any UK decision of that nature.
Well, I think we have always been clear that the capital markets union, which one of the core elements and which what every economist will support is that size, you're trying to get size, you're trying to get the benefits of scale, and that in itself results in more competition, more choice, and so one of the founding elements of the capital markets union is to create scale. That is also underlying in all developments in the past 30, 40 years of creating the internal market for financial services. And obviously, if the biggest capital market is not part of that capital markets union anymore, that has a clear detrimental impact on what we're trying to achieve with the capital markets union. I think on securitization and SMEs, maybe first on SMEs, I think it's very clear that, as you can expect, is in terms of trying to create an internal market and a capital markets union, creating that for the largest listed companies, we have done that first. So we have improved enormously in the past 3-4 decades on consistent regulation and supervision of large listed companies. And I think in reality you can say now also with the post-trading side being very much harmonized is that we are very close to a capital markets union for large listed companies. And as you rightly say, the more difficult issues are around the smaller and medium-sized entities, and especially those that are not listed or are ready to be listed, or smaller ones that are listed if you're looking into that category. And information barriers play a very important role in that part. If you want to invest in a foreign SME, you want to understand the risk, and so everything that has to do with information on risks, so financial reporting information, accounting information, ratings, rating information, we know that it is more problematic, accounting information, rating information in a cross-border situation, and obviously also insolvency procedures, especially for smaller entities where there's a higher risk that there is a failure, is that there might be bankruptcy or that there might be trouble, and that you need to look at what happens when there are insolvency problems. That is especially important for SMEs. So I think it's very good that the European Commission started the consultation of the insolvency procedures and trying to get more harmonization. That will be extremely difficult because this is in the areas of corporate governance. At the same time, I think we need to do it because it is so important for assessing the risks in this part of the market. On securitizations, I think what we have been doing there, in general, we've been quite neutral on this channel of finance. We have said, it's not our role to identify champions among the funding channels. It is our role to make sure that it's a funding channel that can work. We try to remove inconsistencies there, as we have given as the joint committee together with EBA and EIOPA last year, recommendations in terms of more consistency across the subsectors, across insurance, banking, and securities markets. And what we're now, of course, that is very important for us, is transparency to investors in the securitization market. The final agreement still needs to be there. But as I said, it is a channel where we need to make sure that it can work, but finally it's up to the market participants to decide to what extent they want to use that channel.
Thank you for that. I'm going to move to a topic which may invite participation from the audience, which is the Market Abuse Regulation, or MAR. And I think a lot of our members here, Mr. Maijoor, would be focusing on MAR as we speak, particularly if it goes live on July the 3rd, which is very close. And this is a file that's been managed alongside MiFID because of the strong links between those two. I think the investment recommendation section in MAR in particular is causing a fair amount of concern discussion amongst market participants in relation to the traditional sales, client relationship practices, particularly in regard to market color and coverage. Do you have any particular thoughts on that, on the MAR investment recommendation requirements? I would invite anybody in the audience that actually is involved in implementing MAR for their firms, if they want to stand up and give us their impressions about the challenge for member firms, I would find it very welcome. There are microphones, I believe. But perhaps we could start with you, Mr. Maijoor, and then if we have someone brave enough to take up that issue in the audience, we'll invite them to do so.
Well, as you say, the start date for MAR is very close. We understand there is some need for clarity to the market on the implementation. We were talking earlier about MiFID, MiFIR. At the same time, we also delivered the technical standards relating to MAR. So, the earlier the Commission gives clarity on these technical standards, the better it is. On the specific issue of the investment recommendation, that would be precisely an issue without going at this stage in the definitions what would be a recommendation and what not. And it needs to be clear that it needs to be disentangled from, let's say, advice as it's considered within the MiFID world. This will be an area where you can imagine that we would give a Q&A to help with the interpretation and giving help in terms of what we would consider to be an investment recommendation, what would be a recommendation under the MAD-MAR requirements.
Do you see the greater challenge, though, educating the member states or the industry educating its sales forces? Because I suppose both are essential steps in whatever the timetable is on MAR in the implementation that we need to...
I think in general, in terms of education, if you refer to the need for stakeholder interaction, obviously stakeholder interactions are very important for ESMA. So for example, all the technical standards that we have made on MAR are coming out of a standing committee which is populated by national regulators, but every standing committee in ESMA also has a consultative working group. I'm quite sure there will be a member of that consultative working group on MISC. There's a good chance that there is a member of that committee here in the audience, and so that is also the place where there is the conversation. So this is not about lecturing each other. It's about understanding the objectives of the rules and regulations. It's about understanding how the technical standards will work in practice, and on that basis, we'll try to go forward, give possibly Q&As or any other possible instruments that can help with supervisory convergence.
I was just worrying slightly about the timetable, though, since it could be extremely imminent.
Yeah, the only thing is that we feel reluctant as a regulator to now give that clarity in terms of the timing of the issues related to data obligations under MAR, as we think it's first now up to the co-legislators to take a decision on the delay of MiFID. I understand that the delay of MiFID and the piece of legislation arranging that delay, that there is also elements of MAR related, and therefore we don't feel comfortable to give further guidance on the start day and the data obligations under MAR, but you can be assured that once there is clarity from the level 1 on the delay, related to that also the possible implications for MAR, that we will very quickly come with a communication and try to get clarity, depending, of course, on the final wording of that agreement, that political agreement.
Do we have anybody brave enough to take up this subject from the membership? Don't see any hands.
Seems all clear.
It must be all right on the night, so we'll cope with that. I think just if I could, you've raised the issue of level 1, and I'm very conscious of the fact that you have been part of the Commission hearing on the cumulative impact of financial services legislation, and I'm also very aware of the constraints that ESMA has to work within in respect of level 1. I mean, I suppose my question would be, could we see a future in which ESMA has an earlier engagement in level 1 so that problems get anticipated and addressed earlier in the process than perhaps they are today. It may be an ambition, but I suppose it really goes into the more fundamental issue of the impact on markets of prudential regulation, and which I know you're very aware of, and you've demonstrated with your concerns about liquidity. So do you see a change in the kind of architecture as it affects ESMA in relation to the trilogue and the workings of... It's a very big topic. And
it's a lot of elements in one question, Robert. Maybe first on the cumulative impact. I think, as I've said on Tuesday by the hearing, which was very well attended, a big audience on the cumulative impact. I think it's very important for us to get evidence on the impact, and the more evidence we get, and some of your membership has really helped with giving us data, but the more we get in terms of true evidence of the implementation of pieces of legislation, the better it is. And at the end, as a regulator, what we want to do is we want to be a good regulator. We want to have regulations that work in day-to-day practice, and so we need to have evidence on how it impacts. I think one of the big issues related to data obligations, reporting obligations, is one of the biggest concern of stakeholders. We understand that with the quick rules and regulation making in response to the financial crisis, is that you can imagine some improvements there. There's been some comments on the double reporting on OTC derivatives. The double reporting will continue to securities and financing transactions regulation, but in a more modified way, where there will be some benefits for non-financials where they can rely on the reporting by the other counterparty. At the same time, I should say that more reporting will be part of the securities markets, because as I said earlier, I think when we were supervising and regulating securities markets before the financial crisis, we were doing it in the dark. We didn't understand what were the obligations of the counterparties to the OTC derivatives transactions, which was one important part of the financial crisis. We didn't have the information. So more data obligations are here to stay. At the same time, we can improve and streamline their collection, and at the same time I fully understand that it's our obligation then to actually use those data. But as I said before, when we now take a central clearing decision on derivatives, it is evidence-based, where we actually have the data on those transactions across the EU, and whether it makes sense to go for central clearing. I think on the trying to have more influence on and being more involved in the level one, I think there are two elements. First of all, we have been criticized to be very transparent, and for those of you that are following us, for not following the level one, in the sense that when we delivered our technical work, our level two work, that there were questions. Is it consistent with what was agreed at the level one? As we are not part of that level one, it is sometimes difficult to understand what were the intentions, and fully respecting the political setup, of course, of the lawmaking process. We don't want to bring ourselves into that process, but more transparency to us on these type of intentions during the negotiations would be helpful, and also to prepare our level two work. So that is one element of it. The other element is that I think as an authority and with expertise on rules and regulations, I think on some cases we also should comment and give opinions to the EU institution bodies about how can you regulate things in a proper way. We have done it, and we have done it a few times. Last year, for example, we have done it on crowdfunding, where we gave a recommendation to the Commission on the regulation and supervision of crowdfunding. And I think it should be part of our role as an authority and as a source of expertise to give recommendations on the level one.
Well, before we wrap up, are there any files or matters that we haven't picked up on that would be, you think, relevant to this audience?
I think we have covered quite some areas, Robert. So.
Well, I think if I may just say on behalf of the ICMA how much we appreciate the dialogue that we do have with ESMA. Your chief executive in particular has been a stalwart participant in our regulatory policy work, and we appreciate the way you've demonstrated your support for ICMA, coming to our meeting each year and providing such a comprehensive update. I do have one quick question down here, if we can get a microphone. is it? Where is the microphone? Since there doesn't appear to be one, maybe you could... Oh, it's been passed along. Good.
Hello. My name is Pauli Mortensen. I'm representing Nordisk Bank, which is presenting the buy side of the bank, the Sovereign Wealth Fund, Nordisk Bank Investment Management. My question is on the post-trade transparency for less liquid bonds. As I understand it, and as it looked today, national competent authorities can on a discretionary basis decide on deferral regimes for different types of less liquid bonds that can vary from 48 hours to 4 weeks. For a large investor, this means that we will select counterparties on large size bond trades based on the counterparty's jurisdictions. I think this will, to some extent, create an unlevel playing field for those who are still willing to provide liquidity. So from a buy-side perspective, it is of utmost importance that regulation is not implemented differently in various jurisdictions. Do you think this will be addressed before MiFID II go live in January 18?
I think you have to manage expectations here. As you know, the level 1 is giving a lot of variability and a lot of possibility for choice in terms of the post-trade transparency regime, whether it's 48 hours or whether it's longer, and then depending on whether it's aggregated data or whether it is more detailed. That is the type of supervisory convergence where the level 1 allows quite some diversity. So that will be obviously much more difficult to converge and to harmonize. I personally, I see the point that there would be a benefit in trying to be as harmonized as possible in this area, and we will try to get that harmonization. On the other hand, we have to respect that in this area there is quite some diversity is allowed under the level 1. So that will take typically also more time to get that to get to a more common position if there is willingness to get there. Because the level 1 gives quite some, options and possibilities to diverge.
It's certainly interesting to hear a major buy-side participant make the case for selecting its counterparties based on this jurisdiction.
And this is a level 1, so this is not a technical standard. We cannot change this with a technical standard. This is embedded in the level 1, and so in any way we will not have strong measures to ensure convergence here. That will be an area where, on the basis of convincing and hopefully once the mechanism starts to develop, it appears that there is a limited divergence, and the less there is from the start, the more easier it will be to get convergence.
If there are no more questions or comments...
There's one.
Oh, one more. Okay, please, at the back here.
Not there.
Good afternoon, it's Alex Merriman from Securities Services. A question about the EMEA review, if I might, Mr. Maijoor. I wonder whether you might just do a little bit of crystal ball gazing, and we're all waiting with bated breath about what the review might bring. But from ESMA's perspective, what are the areas that you would like to see potentially changed that really are not working at the moment? Thank you.
A couple of, I think I can give you, just from the top of my head, 3 areas I think what would be helpful. First, we should be able to give higher fines and strengthen our enforcement. So, we need to take data quality very seriously. We focus very much on the data quality in trade repositories. We had recently enforced against a problem in a trade repository, but the amount that we could award, and the reason we have noticed hardly any discretion as an authority in terms of what kind of fines we can give. the fine was too low. This is not anything against this specific trade repository, but in general, if you want to give strong incentive, I fully understand that industry doesn't like all these data collection obligations, but at least you want to be sure that if you live by the rules, is that also your competitor needs to live by the rules. And so a credible enforcement mechanism is an extremely important part, and the fines that we currently can give under EMIR to trade repositories are too low. It also holds, by the way, for credit rating agencies, but I think that is less relevant in this environment. Second area, I think two areas that relate to data obligations, maybe more for the non-financials, but you will see them as your clients and be involved with them. We have now, for determining whether you are subject to the central clearing requirement, there are these thresholds. And whether you hit the threshold, yes or no, depends on only your non-hedging derivatives, so those derivatives that you don't use for hedging. That results, of course, in lots of data, in administrative obligations in terms of what is used for hedging, what is used not for hedging, and that determines whether you hit the thresholds, that determines whether you need to move to central clearing. We would prefer not making that difference anymore, because we also think from a stability perspective, both transactions are important. You, of course, then need to increase the threshold, and in the end, I think it would help in terms of reducing the administrative burden, especially in this case for the non-financials. And finally, on the reporting, I already briefly commented, is that the reporting, the double-sided reporting with the adjustment as we are now seeing in the securities and finance and transactions, I think would also help in terms of reducing the administrative burden.
I think on that note, may I just thank you for your participation at this conference and for your continued support for our association, and perhaps you could show your appreciation for Mr. Maijoor's
Thank you very much.
Thank you very much.
Very good being here. Thank you very much.